Hello, and welcome to our EPM webinar in which we're going to be discussing the COVID crisis, employment issues, and bringing staff back to work and some of the issues surrounding that. I'm Richard Smith, and I'm Head of Product with EPM, and I'm going to deal with a number of questions that customers have been asking us recently. In this session, some of the key questions we're going to be addressing are around the practical issues in returning employees to school, how to deal with risk assessments and your obligations in that respect, cases where people are saying they won't return to work because of what they're saying is serious and imminent danger and the legal implications of that, how to deal with situations where you have employees who are shielding or are otherwise vulnerable, and I'm also going to be dealing with changes to the scheme around coronavirus job retention, the furlough scheme. So the first big question that we're going to address is whether or not you're entitled to expect employees to return to work as the school starts to reopen, and how to deal with those cases where perhaps an employee is objecting to returning to work. So in answer to the question, can I expect employees to come back to work as the school begins to reopen for more students? The answer is yes, you can expect employees to return to work. They're due to return to work under their contract of employment, and if they fail to do so, then it might become a breach of their contract of employment. However, to start with, what many employers are doing is to survey staff to determine whether or not they're happy, willing, able to return to work, and what concerns they have, how they may be alleviated, and also to identify employees who've got particular reasons for not returning to work at this point, so that appropriate arrangements might be made if appropriate. Schools are emphasising that safety is their primary consideration. The safety of staff, the safety of students, absolutely the heart of school decision making, and by doing that, it helps employees to understand that you have their interests at heart and that you are not going to do anything that puts them at risk. That in turn helps them to decide that they are going to come into work. Employees who fail to attend or who refuse to attend, unless they have very good reasons for so doing, and I'll deal with cases in a moment where people say they have health and safety reasons for not attending, could indeed, as I've indicated, be considered to be in breach of contract, and you may then decide that you're not going to pay them for their time if they're not working. It may be that we start to take procedural action against them for not working. If somebody does return to work, there are going to be some things that are the same as before and some things that are going to be quite different. It may be that we require people to do different duties. So, for example, it could be that we're asking a Year 3 teacher to deal with reception students. It could be that we're asking somebody to lead on a group of students as a teaching assistant in a separate classroom, delivering teacher-prepared materials. These things are matters that you're entitled to expect from staff, although there will also be things you can't expect people to do. So, for example, teachers ought to be undertaking, broadly speaking, teaching duties, and you can't expect other members of staff to undertake, on anything like a permanent basis, duties that are normally associated with teachers. It could be that you need to think about the rules of employment and whether or not modifications are required to codes of conduct, to behavioural standards, how to deal with transgressions, how to deal with employees who might be breaching the rules. These are all practical matters to think about before bringing people back to work. Our emphasis, and the emphasis of the schools we're working with, has largely so far been on persuasion and reassurance rather than a stick, and we're finding that this is working really well in getting people back into the workplace. Schools are aware that they need to undertake risk assessments before returning employees to work. The question that then arises is how much detail do you have to go into within the risk assessment? The level of detail that needs to go into the risk assessment is really as follows. You need to document the control measures that you have in place to minimise the risk of somebody contracting COVID-19 when at school. The government guidance should form your starting point. Things to consider might include how you stagger pick-up and drop-off times to prevent groups of people congregating, and to mark out socially distanced waiting zones. Once in the school, how can you minimise interaction between bubbles? For example, do you need one-way systems around the school? No shared classrooms between bubbles? Perhaps staggered playtimes or lunch breaks? Cleaning along with social distancing are critical, so build this into the education of employees and students and reinforce with signage and ongoing reminders as to what's appropriate. What you're doing also needs to be communicated to staff and parents so everybody can play their part. Briefings and guidance is really important. Finally, for individuals that may be more vulnerable, we need to look at those on a case-by-case basis. You don't need to undertake a specific personal risk assessment, but we should demonstrate that the controls within the school are robust enough to deal with those individuals, and it may require conversations with them to determine the right way forward. One of the key questions that's being raised, and it's been trailed a lot in the media, is the idea that employees can refuse to attend work, quoting Section 44 of the Employment Rights Act. This is something the trade unions, particularly the NEU, have been quoting both in the press and in letters to employers. So we'll find out what the position is on that now. There's been a lot of talk in the media recently about this provision, Section 44 of the Employment Rights Act 1996, and also Section 100 of the same Act. Section 44 prevents employees being subject to detriment in certain circumstances, and Section 100 makes a dismissal on health and safety grounds automatically unfair. There are various circumstances set out in the Act, which include circumstances where an employee refuses to return to a workplace or leaves a workplace in circumstances where they reasonably believe that there is a serious and imminent danger either to themselves or other people. What trade unions and others have been saying is that if somebody is not satisfied of the safety of their working arrangements due to the risk of COVID-19 infection, then they're entitled not to attend and they're entitled to leave that workplace. Well, that's not completely certain because it could be argued that the danger is not necessarily sufficiently imminent and that the section isn't really designed to deal with this sort of case. However, it is an argument that we need to be aware of because the consequences can be quite serious. There's no qualifying period of service for such cases. There's unlimited compensatory awards in cases where there is a dismissal. And of course, we don't want to be disciplining or dismissing employees for refusing to undertake their duties. We want to persuade them to undertake their duties. So our advice at the moment is that dismissal, disciplinary procedures are where you get to if you have been unable to persuade the employee to return to work. It might be a possible course of action for us to take. It may be possible for us to say no work, no pay. This if you fail to attend work without reasonable cause and you are not in one of those categories who simply must not attend work, then effectively you're in breach of your contract and that you wouldn't be entitled to be paid. And we are mindful of these provisions, but we don't think that they're quite the strong defence that the trade unions and others are promoting at the moment. We've already answered the question in relation to employees generally returning to work, but there are some categories of employees, shielding and vulnerable employees, and there are special considerations for such employees as to whether or not they can return to work. The position of employees who are shielding or who are otherwise vulnerable needs to be particularly considered. Employees who are shielding are those who've got the most serious health conditions and who've been specifically advised by government not to attend any activities outside of the home. They should be staying at home and self-isolating, and it would be inappropriate to ask them to return to work. Secondly, there may be employees who, whilst not shielding themselves, live with a household member who is shielding, and schools are often picking this up through staff surveys. We should be careful, however, not to intrude upon the medical records of the individual who is not our employee, because it would be a breach of GDPR regulations to try and discover the details of their medical condition, or indeed to keep records of it. For those employees who are not shielding, but are perhaps vulnerable due to age or having some other medical condition that means they're slightly more vulnerable but are not required to shield, we should ensure that our overall measures are appropriate, that we are maintaining social distancing within the school setting and considering still continuing home working if possible. If that isn't possible, however, it could be that a return to work is feasible, provided the right measures are in place. Some employers have been asking the question, before a vulnerable employee returns to work, can I get them to sign a disclaimer absolving me of responsibility for any harm that arises from their return to work? This question of whether it's appropriate to obtain a disclaimer from an employee has been raised by quite a few schools. We have a clear view on this, that it's inappropriate. The duty of care rests with the employer to ensure that the workplace is safe, and if there's a concern that the workplace is not safe or appropriate control measures not present, then the employee should not be allowed to return to work. In any event, such a disclaimer would be legally unenforceable if it seeks to exclude liability for the negligence of the employer in failing to provide a safe place of work, which results in death or personal injury to the employee concerned. And we also think that this would be seen as a negative by employees and trade unions if such disclaimers were to be expected from staff. So whilst we understand the motivations, we don't think it's the right thing to do. There's been lots of media attention around furlough, and in particular the idea that now employees are going to be able to possibly return to work part-time. What is the position on this? The Coronavirus Job Retention Scheme, Furlough, as it's often known, has been one of the great innovations of the recent months in dealing with this crisis. It's something that we've all had to come to grips with. And it's gone through many revisions already in its short life. The first point to note is that the government has been really clear all the way through that for employers in the public sector, it is not expected that they will use this scheme, and that it's not expected that they will furlough staff except in a few exceptional circumstances. Well, in schools there are some exceptional circumstances because there's a whole variety of roles that are not funded by government but are funded by parental contributions or other revenue streams. For example, out-of-hours workers in breakfast clubs and after-school clubs, letting staff, people who work in sports centres and the like. So we are finding cases where schools have had to think about furlough. Well, we know that you do have to be careful with this because government has also been clear that they may order in years to come, and it could be in 2 or 3 years that government looks at your records and says, well, you made a claim for furlough, but you shouldn't have done, so please give us this money back. So we are advising employers to be cautious in the claims they put forward, because you might be paid now but have to find the money later on. The most recent developments are that this scheme has now been extended to the end of October this year, at which point we expect it to close, that new entrants to the scheme have to have come on by the 10th of June, and if they haven't, then there's going to be no ability to furlough them thereafter, that there are going to be some changes in July, so that employees are going to be allowed to come back to work on a part-time basis, and the employer will pay them fully for the time that they work, but then they will be furloughed for the time they don't work at the 80% of earnings that has been established previously. That from August onwards, the government contribution is going to start reducing, with employer national insurance and pension contributions paid by the organisation from August, and from September and then into October, increasing proportions of the employee's pay will be covered by the employer themselves. Our own thinking is that it's very unlikely that schools will be furloughing staff past the beginning of September, at which point we think there's likely to be a fuller and more normal return to work, although some cases will continue to be relevant even into that period if, for example, there's limited out-of-hours provision for students at that point. We also are advising employers that they need to think carefully about the position in relation to the summer holiday period, when probably employees would not be present anyway, and therefore it could be argued that it would be an abuse of the scheme to furlough staff for a period when they would otherwise have been on holiday and when the employer should be paying them. And just on that point of holidays, where an employee does take holiday during the period of furlough, they're entitled to be paid not at the 80% that the furlough scheme provides for, but at 100% of their pay for that period. We hope this has been a really useful and informative webinar, and you'll keep coming back to look at further webinars as we publish them. There's lots of support available from EPM. Our website contains a wealth of useful information, and we're constantly updating our frequently asked questions to deal with the latest issues that are coming through. We provide full support services to our customers who need assistance with all the HR ramifications of this situation. And we're also providing for non-customers a free helpline that enables you to get access to our skilled advisors so that you know how to deal with these cases and you can understand the latest thinking around what schools are doing and best practice in managing a return to work. Thanks very much for listening. Talk to you again.